SJC-12210, Commonwealth v. Gabriel Cordero.
Mr. Schnipper, welcome. Driving not too bad from Maine? Vermont, even better.
Maine.
I'm sorry. Not that they're both great states.
Prefer our holistic and eco-friendly division.
Okay. All right, you may proceed.
Good morning. May it please the court. I'm Merritt Schnipper for Gabriel Cordero. The only way to judge whether police behave reasonably in conducting an auto stop is to look at what they actually do. What the trooper in this case actually did was perform every justifiable investigative task while following the defendant for nearly 15 minutes. When he finally pulled the defendant over, the trooper acted as though he still needed to accomplish that investigation, even though he already knew the defendant was fully licensed, his car was properly registered, inspected, and insured.
Well, he didn't know the defendant was the defendant at that point, though, right? So if he follows
Not
someone,
the person operating the vehicle.
right? So he has a right to go to the car and see that John Jones is John Jones, and
Of course. And as I show in my brief, the record evidence shows that he was presented with a photograph in his onboard computer of the defendant. So
But you can check all that. You don't disagree with that.
Oh, sure. I'm not saying that he can't take a look and say, yes, what the information I received is actually correct. But what I'm saying is that by the time he arrived at the window of the vehicle, he knew that Gabriel Cordero was properly licensed to drive. He knew that this vehicle was owned by Gabriel Cordero.
in the continuum, where should it have ended?
Where what he should have done was approach the vehicle, confirm that the driver was that the licensed owner and operator was indeed the person driving it, decided whether he was going to issue a warning or a citation for the observed taillight out and the window tint issue, and sent him on his way.
Well, what about doesn't he have a right to check the tint, and then when Mr. Cordero says, I want to show you some paperwork from a repair shop, and he went outside and he looked at that, does he have a right to do that?
Let's go back before the I want to show you the paperwork. So he certainly has a right to check the window tint. And as I suggest in my brief, the record evidence shows that he was aware from the moment he saw the car that it was his words were significantly below the 35% legal limit. So he knew that. So then whether he needs to, I suggest he leaves it behind, even though he certainly could have brought it with him and just checked it while he was there.
Well, it's safety concerns perhaps for not bringing it with him.
Sure, so let's say he wants to leave it behind because he says, let me go up unencumbered. He still, basically, all he needs to do is see who's driving, confirm the tint, and issue either a citation or a warning. So instead, he decides he's going to go back to the vehicle, run a records check, which he's already run while he's following the defendant, and then he's going to call for backup and wait for backup to arrive. At that point, he's going to come back and say, I want to have some further
So
conversation.
we're going to tell the police that they can't call for backup under your scenario?
Oh, I'm not saying that as a general matter they can't call for backup. What I'm saying is that in every case, the courts need to look at what actually happens in the context of the particular stop conduct that's occurring. And so in this particular case, there was no real justification for calling for backup, because to the extent that the trooper was calling for backup on the basis of the fact that he's out on a lonely stretch of road somewhere conducting an auto stop, he's made a conscious decision not to stop, in the significant exit ramp structure that exists at Lee, in the center of the town of Lee, and he's instead going to follow all the way through the center of Lee, follow out into a rural area, and then elect to first conduct the stop after he has already determined all the things that he normally would be determining, after he takes the license.
But it's okay, though, for him to check on the paperwork. It was okay for him to basically ask for the license and registration,
I think the law is pretty established.
even though
that it is.
he knew it was already okay.
Well, certainly,
But
because
he
there
can
is a legal
double-check that. He wants to
requirement
see it.
to carry the
Have it.
certificate.
Right, and it took him a while to find the registration, right? So,
Well, that's correct. I mean, the judge, in fact, did not find that a registration certificate was ever produced. If a license was produced, but not a registration certificate. That's what the judge found. The question becomes what level of delay and what level of sort of holding someone and seizing them is justifiable when we already know that the registration itself, the lawful process of registering the vehicle with the state, has been accomplished. Licensure is proper. So the only potential issue is not whether we've got an unlicensed driver, it's whether someone's not carrying a statutorily required certificate, which has a $35 fine associated with it for not carrying it, but doesn't bring to mind the larger concerns about whether this person is lawfully operating this vehicle, which...
But
Can I ask a question about, just factually, and you may not know, but I was trying to understand why the defendant didn't just return to his car as opposed to agreeing to sit in the police car handcuffed?
That's a question that I myself have asked myself many times while I'm over this transcript, because the facts show that this is a person who has had prior interactions with the law and actually has served a prison sentence in the past. And although that's what the trooper testified, it frankly defies belief for me as a criminal defense lawyer to believe that a person with that background would agree to be handcuffed and put in the back of a police car when his own vehicle was sitting right there by the side of the road and he could have returned to that. So the record doesn't speak to exactly why, but it is a bit difficult to accept that finding, which the judge did make, though.
Now, how do you factor into this equation the defendant's extensive criminal history, which was known to the trooper?
Well, I think that's really, in a way, gets to what's really going on here, which is that we have a person, and there's no contention that it's not appropriate for an officer when, conducting a stop to get that information before they approach a car so they know a little bit more about what they're heading into. The question is, in the absence of any issues related to the operation of the vehicle itself, there's a civil motor vehicle violation that's observed, but in the absence of any question about the licensure or the registration or the propriety of Mr. Cordero himself driving and using this car, how much mileage does an officer get out of the fact that someone has a criminal background, but there's no indications of criminal wrongdoing in this particular context? Because what we have here, and this is a significant distinction from cases like Commonwealth v. Feyenoord, which is what the motion judge relied on in Commonwealth versus Wright, an appeals court case that the Commonwealth has directed this court to, because in each of those situations, what started out as a taillight out or a failure to use a turn signal or something is escalated when the person cannot produce paperwork that basically shows their entitlement to operate the vehicle. In this particular case, the officer was very clear in his testimony that before he even pulled over, he needed to confirm that Mr. Cordero was the operator. But once he had done that, he already knew that everything about this vehicle was proper. So, we have a person who, yes, has a criminal background, but in this particular case, other than having a civil motor vehicle violation, is operating in full compliance with the law.
What does the officer have any right to take account of the I think he talked about the nervousness and stuttering of
It's the
your
same
client?
thing as with the criminal record, I'd really say. So,
Because
obviously.
the criminal
it's
record is a thing in the past.
Sure. Current behavior is nervousness and stuttering. But, so I would say it's not nothing. It's certainly something in the cases we see very frequently cited by officers as a reason that they believe they need to do some further investigation. But the question that's raised is, without the anchor of some issue about the operation itself, what can a police officer take from the fact that a person's nervous in the context of a vehicle stop in which the paperwork is already in order? So I would say it's not nothing. It's not significant enough to extend a seizure beyond the sort of legally visible justification for that seizure. And of course, as I say in my brief, I talk about the court's recent
Then it
decision.
turns out to be nothing, correct?
I'm sorry?
Well, doesn't it turn out to be nothing then? Because
Right, well, what I'm saying is it's a factor that's been used in many cases to assess the overall reasonableness of a seizure.
The
And
same,
it's-
the same for the fact that the officer thought he deceived him regarding where he was coming from?
Well, again, right, these are all, they're factors in many cases, but I think that without an actual concern about lawfulness of operation to anchor it to, while it might be something that would justify the interest of a police officer, it's not enough to justify extending a seizure beyond the time necessary to perform the legitimate purposes of the stop, which is basically, checking that the licensure is in order and giving either a ticket or a warning for the violation.
Mr. Schnipper, let me ask, this case looks to me like a clearly pretextual stop, but I know that our cases, Santana and so forth, say that's okay. Do you think that the court should do anything specifically related to the limits of pretextual stops in this case, or can it just be resolved by looking at, as you said at the beginning, what the police officer actually did, and if we assume that he prolonged the stop too much? Do you think that we should have some kind of limit on pretextual stops? I'm repeating myself, but.
I do think you should.
Yeah.
I completely agree with you there. And I think that this case actually provides an interesting way into that issue without having to get into what the court all the way back in Santana said it was not going to get into, which is subjective officer motivations, and that's really largely an issue of the impossibility of the proof of these matters. But if we look, that case also said we're going to look at objective reasonableness in the context of an auto stop. And at that time, in 1995, the court said it's an objectively reasonable stop if there's a facial basis for a pullover, a light out, a missing inspection tag. But what the court also said is we need to look at the way the officers handle themselves during the stop. And in the United States versus Rodriguez case that I cite from the U.S. Supreme Court, they talk about looking at what the officers actually do. And here, I think the way to sort of limit pretextual stops, still under the concept of the authorization rule, is to look at what police actually do. And they say looking at the pre-stop conduct. And so what we're looking at is, yes, an officer had an objective basis to make a stop because the light was out, but also what they had objectively already done was conducted virtually all the legitimate law enforcement tasks associated with the stop before they made the stop. So now, again, that may be advisable police conduct. It may even be reasonable and commendable police conduct. But what it means is that there's a much more limited time after the stop for the police to interact with the motorist. And so the Justice Ginsburg opinion for the Supreme Court there said, if a police officer can achieve his or her tasks efficiently by doing it diligently, then that's the time that's reasonably required by the Fourth Amendment to complete the stop. You cannot purchase yourself additional time for unrelated criminal investigations by diligently performing the tasks that you're legitimately permitted to do by the Constitution. So if you are going to basically conduct the vast majority of a legitimate auto stop task before you pull somebody over, then you're going to have a much shorter reasonableness window under the Constitution.
Is it legitimate for a police officer to agree with the defendant to go outside and look at the tail light when he wants to show him some information? Was that a reasonable step, or was that purchased in time by the officer?
I think that it's fact-specific. I think it is reasonable if a person says, I'd like to show you something, for the officer to say yes.
Right. I mean,
I'm willing to let
thereafter, you may say that it should have stopped once he confirmed that, yeah, he's going to get it fixed.
That goes to the question possibly of whether you're going to issue a citation or a warning. But, the officer says, well, Mr. Cordero, I really still don't understand, where you've been going to and coming from today. And the truth is, he's already run his record twice. He knows that he's legitimately operating the car that he owns, and a member of the public has a right to drive on the road anywhere they want. So I think to basically say, well, I'm going to have to hold on to you a little bit longer because I need to understand a little bit more about whether you're coming from your cousin's house or just up the road, this is exactly what is prohibited. It's just sort of extending the seizure for this very limited purpose in the hope that reasonable suspicion will eventually turn up.
So if we look at it in terms of an interrogation, although it's obviously that's not the legal terms, but if we look at it as far as a police officer looking for more information that's unrelated to the traffic stop, then it may exceed the permissible limits of a traffic stop.
I think that's exactly it. What's the legitimate purpose for which he can pull over this motorist? Has he accomplished those purposes? And is this additional questioning related to those legitimate purposes, or is it for some unrelated criminal investigation that is not justified by the facts of this particular case? I mean, it's a different case when you turn up the registration with somebody else's name on it, or it's in one state, and or there's some question about whether a person can operate their vehicle lawfully. But because you know that going into the stop.
All of which is true in Feyenoord, but not here.
It's in Feyenoord, not here, and it's even in Wright, the appeals court case, not here, and I would specifically say with regard to the record issue about how much the officer knew about criminal background, in Wright, there's some telling facts in that record about what really come out of the mobile data terminal and its sentence length and some other and that was an out-of-state sentence, and here we're talking about Massachusetts sentences, so it stands to reason that the police officer has greater access to Massachusetts correctional records in their car than they do to Vermont, which is the stated issue in the Commonwealth versus Wright case.
Can I turn you, in the brief time you have left, to the issue of consent with regard to the search?
Absolutely.
What we have here is, I then asked him a third time for consent for the trunk of the vehicle. What was his response? Then that he gave consent for it. Do you remember what he said in order to give consent? I do not. But you remember him giving consent? Correct. Is that sufficient for a judge to find consent? And if not, why not?
It's not sufficient, and it's not sufficient. There's a separate issue about the standard of proof the Commonwealth was able to satisfy, but regardless of the standard of proof issue here, it's not sufficient because this court has specifically said in Commonwealth v. Rogers the Commonwealth needs to present us with more than an ambiguous set of facts that leave us guessing about the nature of the interaction and ultimately the question of voluntariness. So it's really notable in this particular case that every time Mr. Cordero declines consent, the officer witnesses say exactly what he said: I want to go home to my kids. I only have a plastic bag of laundry in the back of my car. When he's giving consent, or ostensibly giving consent, he just says, well, he consented to it, but I can't tell you what he really said. So that just strikes one as a little too ambiguous to justify crossing this constitutional threshold. And then there's the separate question of whether there was a coercive aspect, because you're handcuffed in the back of a police car, an officer is standing with his drug dog waiting in the wings, and he's asking you serially, he's standing at the window serially asking you to consent. He's not saying, I analogize it in my reply brief to the Miranda warnings. We have to step back for a second and give the person time to think about it. You're just sitting there. Do you want to consent? No. Do you want to consent? No. Do you want to consent? He gave consent for it. So there's a badgering aspect that goes to the coerciveness finding, especially when you're talking about handcuffed in the back of a police car, surrounded by 3 cars, and with the dog waiting in the wings. So I think it is too ambiguous for this court to find consent under its existing precedents.
And in your view, in any event, we wouldn't, the way you look at this case, we wouldn't even need to get there.
You don't need to reach it at all.
Okay, thank you.
Thank you.
Mr. Calaflores, you came a long way too, didn't you, from Berkshire, so welcome.
Yes, Your Honor, but I had a shorter commute from my parents' house this morning. so
Aha.
A little bit better, a little more
Aha,
traffic.
that's the secret, to live on the DA's salary, huh?
Good morning, and may it please the court. Joseph Calaflores for the Berkshire District. I think what it boils down to is, as Justice Gaziano puts it, is where in the continuum is the proper length of a stop. And in a typical police officer, when they stop a motor vehicle, they approach, and one of the first questions they ask is license and registration. And that's for a specific purpose. There's a law here in Massachusetts that requires an operator to have both his license as well as the registration for the motor vehicle, or he faces civil fines. So that's the typical first question. Now, upon asking that question, that is the moment where the defendant starts to give inconsistent answers to questions of where are you going.
How does where you're going have anything to do with the traffic citation?
It doesn't. The question is kind of filling the gap of where he's looking for his documents. Otherwise, the officer is just standing there. It helps fill the time. But the question isn't really anything that's going to the purpose of the stop. But his answers that are given really betray the nervousness that the defendant is feeling at that moment. He says, I'm coming from just down the road, but the trooper had observed him leave exit 2 on the Pike and travel the 6 miles into the next town over.
So is the rule to take from this is be loquacious as you can, because who knows what's going to come out of the defendant's mouth?
Well, I think the case law says where the officer is not to ignore what he observes and sees when approaching a vehicle. We have the testimony of the officer, the trooper, that he approaches the vehicle. He cannot see into it because of the deep tint. And when he approaches, he starts to ask for license and registration. He then starts to ask where he's going.
But once he finds out that Mr. Cordero is Mr. Cordero, and then he finds out and measures the tint, and then he takes his explanation for the taillight or whatever was broken in back, isn't it over?
So we have to look at the totality of the stop. So in defendant's brief, they argue that the trooper should have walked up, tint meter in hand, rolled down your window, slapped it on, got the tint reading, issued citation.
I already got you to using the tint meter.
Right. So
into talking to him about the taillight.
So we're progressing through all the facts, and at the moment where he says, I just got into an accident, I've got all these papers, can I go look at it? That is not at the request of the trooper. That was an offer by the operator, the defendant of the operator of the vehicle, the defendant. So when he removes himself from the vehicle and goes to the rear to look at the taillight, at that moment, he's offering more explanation of what's going on that night. Now,
So wait, what's the purpose of the delay at that point after that he's seen the taillight? Both people have seen the taillight. Now what are we doing?
well, ostensibly, there's further conversation at that moment on whether or not, how long ago the accident. There's no nothing on the record to reflect what was in the handful of papers that was presented to the trooper upon return to the vehicle. Ostensibly, that's a conversation happening at the rear of the vehicle because he says, I've got all these, I was in an accident, can I go take a look? And he goes out to the rear of the vehicle. The delay at that point is nothing attributable to either party. It's a continuing conversation which elicits further facts. The trooper at that point is trying to clarify the earlier story, which was inconsistent with what the trooper had personally observed.
But then even after that, he has to get into or he elects to get into the cruiser handcuffed and wait for what?
As to why the defendant asked to enter the cruiser, as far as the reasoning other than it's cold outside, I can't
No, I
speak.
understand, we don't know.
Right,
But,
so-
but why was he having to wait at all, is the question.
I can't speak to what's not on the record, but at that moment, reasonable suspicion had built up.
What was the reasonable suspicion at that moment?
The trooper had run the background. He had seen that he had an extensive criminal record, including trafficking and drugs, and
Okay.
a few various other activities. He saw that the vehicle was registered to Holyoke, which is a drug source city that the trooper knows through his extensive training as a member of the CAT.
So you're saying there's a reasonable suspicion that a crime has been or is about to be committed because I live in Holyoke, I've got a criminal record, and I'm Hispanic. Is that what you're saying?
I would disagree with the part about being Hispanic. There's nothing on the record that that person is Hispanic other than their overt names.
Doesn't the judge say something about that?
I don't
Oh,
recall.
all right, take that out. I live in Holyoke, I've got a criminal record, and that's reasonable suspicion that I can sit here while you get a dog?
It's also a contributing factor that when he approaches the window, he then gives inconsistent statements. He at first says, I'm coming from down the road. He then says, I'm coming from my buddy's house.
So
He
what
then
is,
says
what
he's-
is the crime that has reasonable suspicion for? What is it?
The only crime that I could possibly glean from the record would be that he does have drugs on him.
So, let's look at the totality of the circumstances. I mean, I appreciate the state police's concern for broken taillights in the back, but here's somebody who's following him for 5 or 6 miles. We're allowed to take that into account.
The length of from exit 2 up into just across the neighboring town's line, 5 or 6 miles and approximately, I think, 10 minutes is established on the record. And the trooper does testify that he would have been following that person. That is his normal route up to the Cheshire Barracks where he was traveling to. Cheshire Barracks is a number of towns further north than where they were stopped, as well as it's on that direct road. He just continues traveling north on the numbered route, and he will eventually reach his destination.
And then he stops him in an area that is more remote than otherwise he could have stopped him. I mean,
Well, I would gracefully suggest that it's Berkshire County, Your Honor.
but I know, but he
Ruralness
passed
is-
Lee. You get off the highway and you go right down downtown Lee.
Downtown Lee, sure. but
Okay, and
to-
then
to
he then goes to some remote area.
To qualify a numbered route between two major towns, for a lack of a
Okay,
better term, in Berkshire County, it is not it's more rural, but I wouldn't
I
clarify it
understand.
rural and out of the way.
and the fact that the individual is nervous about this should be given weight? How much weight do you give to the fact that somebody is nervous when a trooper is following you for 5 or 6 miles in a marked vehicle, by the way?
It's not a fully marked vehicle. It's a vehicle that, if you look closely enough, that you will notice it has markings, but it's not a full cruiser with ostensibly, like, it's a police officer
What time
following
of day or night was this?
you. The time was 6:50 p.m. is when they exited the highway.
And so could you see in your rear view mirror that this was a trooper as opposed to just somebody else following you?
I'd have to refer back to the transcript to the exact description of the vehicle, but as I understand it, it is a limited visibility. I believe it does have a bumper bar, but it does not have a light bar that would immediately say there's a Ford Explorer maybe following you with a light bar right on top of it.
So going to your answers to Justice Botsford, let's imagine they were on the street in Lee, and the police officer learned that this gentleman with a Hispanic name is from Holyoke, and that he has a criminal record. And he walks up to him and says, "What are you doing?" And he gives some answer that appears to be unlikely. Is that reasonable suspicion?
Looking at the statements that he did indeed give, I think it would depend where in the town we were. One of the overriding, or at least in my mind, was the fact that they were heading to a Subway restaurant. I'm not sure if this is reflected in the record, but there is one in downtown Lee. The trooper knew that. He drove right by it through the center of town, right into the next town over, and then the next Subway restaurant on that road is further up, right before the border to the following town,
In Pittsfield?
just before Pittsfield.
What if he wasn't hungry yet?
That would be inconsistent with the earlier statement that he's coming from his buddy's house.
What if he didn't see it? What if he didn't see the first one, and so he just says, I'm going to a Subway?
Once again, looking at all the statements given, it's I'm coming from just down the road, which the trooper knew to be false. I'm coming from my buddy's house just down the road, which he knew to be false. And then the third statement is that he was going to a Subway, which he had already passed.
Does it strike you as problematic at all that one should find reasonable suspicion by asking questions that have nothing to do with the purpose of the stop?
Well, it depends on the questions that are coming up. These aren't questions as overt as, do you have drugs on you? This is, hey, it's 6:50 p.m., where are you heading tonight? And then the questions flow from there because the inconsistent statements are given in response. Now, if the trooper had come up and asked a question that is completely, right field as far as crime, then yes, a trooper that walks up cannot immediately start interrogating on drugs on that record. There has to be a little bit more pushing a suspect along to the fact that he may be, and that here is the fidgeting, the nervousness.
Do you agree that the police officers, the troopers' conduct here is just slightly suspect, that he was profiling this guy, and should that matter?
In the context of pretextual stops, I think this may be trending a particular way with it.
Trending?
As far as we had a proper stop, the only potential pretextual basis of it would be that he has a criminal record of drug trafficking. So if you couple that drug trafficking with a Hispanic last name, sure, it does appear to be a pretextual stop.
And Holyoke.
And from Drug Source City, Holyoke. But when you look at what the trooper actually did was he approached the vehicle, he asked for license and registration. There's nothing saying that a trooper cannot pull up the background of a person.
So you think we should validate that kind of stop if you agree that it was pretextual and that it went beyond the checking of the papers?
I'm not sure I fully agree with the fact that it is pretextual. Defense counsel has stated that I've conceded that it is pretextual, but I cite case law because of what it appears to be. I would argue that this is a proper stop where
Even though it's pretextual? That's your position?
I would disagree on the pretextual nature of the
I thought
stop.
you just said you concede that it was.
The defendant argues that I concede in my brief that it was pretextual.
Okay,
I'm
you don't-
not conceding that it was pretextual.
Okay.
I'm saying this was a proper stop where a trooper that is traveling to his assigned barracks sees a vehicle with civil violations, a brake light out, a tail light out, and what appears to be deeply tinted window glass.
So given all that, let's say, how long did they wait for the dog to get there?
So according to what I can gather from the record of the hearing, the call for the dog went out at 7:20 p.m. There was a small delay.
At 6:50, did you say that to start with?
The exit from the turnpike was at 6:50. The stop was at approximately 7 p.m. Approximately a couple minutes is what they stated, so I'm assuming 7:02 to 7:03, maybe 7:05 is when the license is given. There's a call for assistance at 7:08, approximately again, because there's no exact time given. And then going down at 7:20 p.m., there's a call for a dog.
And the dog gets there at 7:40 or 8 or when?
So there are two times given for the arrival of the dog. It's either 7:28 or 7:40, and that's transfer pages 114 and 56.
But whether it's 728 or 740, do you agree when they call for the dog, at that point, there has to be reasonable articulable suspicion?
Yes. And that reasonable and articulable suspicion is that he has a criminal record of drug trafficking. The vehicle is registered in a Source City, Holyoke, and that when he effects the proper stop and asks properly for license and registration, during the time that the operator, the defendant, is looking for those papers, he is giving inconsistent statements, which is adding to the already known factors.
Are there other source cities?
There's nothing on the record as far as other source cities. I'm sure that there are a few known source cities throughout the Commonwealth and potentially neighboring states as well, just by the nature that the trooper that conducted the stop is focused in combating trafficking of drugs.
With regard to the consent, what do we do with what is plainly a conclusory statement of consent?
Sure. After a little more research, I came up with Commonwealth v. Edwards from 2005 that says, consent, a preliminary question of fact, at a motion to suppress need only be demonstrated by a preponderance of the evidence. It is not an essential element to the charged crime. So based on the preponderance of the evidence, we have to look at what's going on at that moment.
But it has to be unambiguous,
Yes.
correct? And how do we know that this consent was unambiguous? Because we don't know whether it was verbal, we don't know what he said, we don't know what he did. We don't really know anything as to what it was that constituted the consent.
The Commonwealth would contend that it is unambiguous when looking at everything that occurs at that moment. He agrees to get out of the vehicle. He agrees to be pat-frisked, which results in a sum of money. He agrees to be handcuffed and placed in the back of a vehicle, even though he is not under arrest. Further conversations, he then consents to a search of the glove box of his vehicle because there is an amount of marijuana in there. The drug dog then arrives, and I would disagree that the moment where the drug dog arrives, the officer arrives, and he's speaking with the defendant, that it was badgering. It is, from the record, it is a 10-minute conversation where he's asked 3 times. I would also disagree with the fact that the dog is in the wings. There's nothing on the record stating that the dog is at his hip or just outside the car. There's nothing to even suggest that it is outside of the dog officer's cruiser.
So you're saying if he was sitting in the back of the cruiser with his hands cuffed, being asked repeatedly if he would consent, that he was free to leave?
I can't speak to what the defendant thought at that moment. Certainly, he placed himself in that position because he was cold when they were standing at the rear of the
He was
vehicle.
cuffed with his hands in the back?
And there's, on the record, it states that he was repeatedly told that he was not under arrest.
So he could have left?
If he had asked for,
Well, could have left as one factor on custody. Commonwealth versus Gordon, I think, is cited in your brief. Could have left is not the be-all and end-all of custody.
It is not. There are a variety of factors.
You've got the Bryant factors, that's one.
And what do we do with the fact that he was twice asked for consent and twice deflected the question? I want to go home to my kids. I only have clothes in a plastic bag in the back.
I would suggest that those aren't clear and unequivocal denials of consent.
True, but how does it bear on the, we don't know what it was that was said the third time. And should we have some skepticism that somebody's going to consent to opening a trunk which he, according to the Commonwealth, knows is filled with heroin?
I would suggest to you that the motion judge who saw the testimony of the 2 witnesses, Trooper Noah Pack as well as Officer Haker, who is the officer with the dog, he was able to properly weigh and give credibility to the testimony of those officers as to what they were saying, as well as the ambiguousness, if I can use that word without conceding it, of the consent.
But I mean, let's assume that the judge credited, which he said he did. Let's assume he entirely credited this officer. Let's assume he's entirely honest. All he said was he gave consent, but he did not recall what he said to give consent. So what is a judge to do with that, even if you believe it?
If it was a sitting judge maybe a little leeway to ask a question to clarify and then allow for a further redirect and cross-examination of that witness.
But to my knowledge, that's all that the record says is in terms of what the consent was, is that the person said he gave consent and that's all. He can't remember what it was which constituted the consent. So how do we interpret, how can a judge interpret that, even if he credits the police officer, as unambiguous consent?
I can't speak for how a judge would act at that moment. I do know that the motion judge did give full credibility to the officer.
But
and
if you
even
do, so I think, let me ask it this way. So we credit, the motion judge credits the officer, and we've got the record before us that we have. And he's in a police cruiser with handcuffs on. Taking those facts and applying them to the standard for consent, which is something like it can't be mere acquiescence, and it has to be unfettered by coercion. Do those facts, taking the facts that are credited, can you get more likely than not to the point where that standard is satisfied, so that it's not mere acquiescence unfettered by coercion when we have only these facts and he's in the back of the cruiser handcuffed?
I would suggest that the facts presented to us are not overtly coercive. There's nothing suggesting that they were badgering him, as counsel would suggest. That the record reflects that it was a 10-minute conversation. And as the motion judge finds, a defendant certainly could, facing all the factors, change his mind willingly.
Okay, thank you.
Thank you.